Judgment in the matter of HXA against Surrey County Council and YXA against Wolverhampton City Council.
Lord Burrows will hand down the judgment.
I must make clear at the outset that there is a court order in place that no one shall publish or reveal the name or address of the respondents, who I shall refer to as HXA and YXA, or publish or reveal any information which would be likely to lead to the identification of the respondents or of any member of their families in connection with these proceedings. These two cases concern claims in the tort of negligence brought by HXA and YXA against local authorities in relation to their social services departments. HXA and YXA were children when they suffered sexual or physical abuse by a parent or parent's partner. The facts or assumed facts in both cases are shocking and disturbing. As a child, HXA was assaulted by her mother and sexually abused by her mother's partner. Her mother's partner was convicted of 7 counts of raping HXA between the ages of 9 and 16, and he was sent to prison for 14 years. HXA's mother was convicted of indecently assaulting her and was sentenced to 9 months imprisonment. In YXA's case, it is alleged that YXA, who has epilepsy, learning disabilities, and autism spectrum disorder, was physically assaulted by his parents and given excessive medication by them to keep him quiet. It's alleged that the local authorities in question should be held liable to pay damages to the claimants, who are now adults, for negligently failing to protect them as children from the abuse that they suffered. The central question that arises on these appeals is whether the local authorities owed the children a common law duty of care. Such a common law duty of care, which is a necessary starting point for there being a claim in the tort of negligence, is distinct from the statutory duties that are owed by the local authorities, in particular under the Children Act 1989. The local authorities sought to have the claim struck out without going to a full trial on the basis that it was not arguable that they owed a duty of care at common law. They succeeded in having the claim struck out at first instance, and those decisions were upheld on appeal to a High Court judge. But the Court of Appeal allowed the appeals of both HXA and YXA and held that the negligence claims should not have been struck out. The local authorities now appeal to the Supreme Court. The Supreme Court unanimously allows the appeals of the local authorities and decides that the negligence claims of HXA and YXA should be struck out because there was no relevant arguable common law duty of care owed by the local authorities to the children. The judgment is given by myself and Lord Stevens and is agreed with by Lord Reid, Lord Briggs and Lord Sales. In general terms, the decisions in these cases turn on the application of the decision and reasoning in the leading 2019 Supreme Court case of N against Poole Borough Council. In that case, it was held that the defendant local authorities did not owe a duty of care to protect children who had been subjected to verbal and physical abuse by their neighbours. It was made clear by the Supreme Court that in this type of case, where the issue is whether a local authority has a duty of care to confer a benefit on the claimant by protecting them from harm by a third party, it is necessary to establish that the local authority has assumed responsibility to protect the claimant from that harm. One needs that assumption of responsibility because imposing liability in the tort of negligence for failing to confer a benefit on a claimant by preventing harm by a third party, sometimes referred to as imposing liability for an omission, is more difficult to justify than where the defendant has itself harmed the claimant by its own negligent acts. And as the Supreme Court stressed in N against Poole, the principles applicable to liability and negligence for a failure to benefit by preventing harm by a third party are the same as those which apply if the defendant is a private individual rather than a public authority. On the alleged facts and the particulars of claim pleaded, there was no relevant assumption of responsibility in these two cases. In HXA's case, the alleged internal decisions by the social workers to carry out keep safe work and assessments of the child's safety within the family were merely initial steps to prepare the ground for a possible later application for a care order. They fell significantly short of being an assumption of responsibility to use reasonable care to protect HXA from the abuse by her mother and her mother's partner. In YXA's case, the local authority was providing respite care on a regular pattern whereby YXA spent roughly one night a fortnight and one weekend every 2 months in foster care. But that did not constitute an assumption of responsibility to use reasonable care to protect YXA from the abuse by his parents. The Court of Appeal had held that the claim should not be struck out because this was a developing and uncertain area of the law where one needed the full facts established at trial in order properly to determine whether there was a relevant assumption of responsibility and hence a duty of care owed by the local authorities to protect the children from the abuse. The Supreme Court disagrees. In the light of the decision in N against Poole, this is not an uncertain and developing area of the law. Moreover, these two cases are essentially indistinguishable from N against Poole. Given that in N against Poole, there was no assumption of responsibility to protect children from their abusive neighbours, it's hard to see how there could be an assumption of responsibility in these cases to protect the children from the abuse by a parent or parent's partner. This is not to say that there can never be an assumption of responsibility and hence a duty of care owed at common law by the Social Services Department of a local authority to protect a child from harm. Two examples are given by the Supreme Court. The first is where the local authority has obtained a care order and therefore has parental responsibility for the child. That is exemplified by the 2001 House of Lords decision in Barrett against Enfield London Borough Council. The second example is that where respite care is arranged by the local authority with foster carers, there is an assumption of responsibility by the local authority to protect the child from harm during the period of the foster care, including the mechanics of returning the child to its parents. But that assumption of responsibility does not extend to where the child is back with his or her parents. So in these cases, applying N against Poole, there was no assumption of responsibility by the defendant local authorities to use reasonable care to protect HXA and YXA from abuse by a parent or parent's partner. Expressed at a more granular level, the particulars of claim provide no basis for the leading of evidence at trial from which a relevant assumption of responsibility can be made out. It follows that there is no arguable duty of care owed as alleged, and the claims in both cases were correctly struck out at first instance. The appeals of the local authorities are therefore allowed.
Thank you. The court is now adjourned.